There has been calls for a broader definition of gig workers to cover more sectors beyond e-hailing and p-hailing. According to ISIS Malaysia's Farah Nabilah Abdul Rahman, recognizing gig workers as distinct from traditional employees would enable regulations to be tailored to the unique nature of gig work.
From categorizing these gig workers, according to the employer-employee relationship, we have several tests, but this is from other countries, like we have common law tests, economic dependency tests, which may be adopted in Malaysia as well to determine whether it resembles employer-employee relationship. And from this, government would be able to precisely craft what kind of protections required and who should contribute.
She added that the gig worker bill must include measures to better protect workers and address unfair treatment meted out by platforms.
But in terms of certain things under the labour rights, such as suspension, they don't have any legal framework to defend themselves. I take a case of IV Law, who actually appeal to government, bring it to the industrial court, but the industrial court does not, basically the rule that this case is not under the industrial court because she's not a worker, she's not an employee, so it is being dismissed. So there is no legal framework to basically protect them. And secondly, they at the same time, they also don't have the right to unionize like employees have. So they don't, at the moment, there is no legal framework at all. So probably what could be done is either extend the right to unionize, which could enable a stronger collective bargaining and a legal, from under the legal framework.
Communications Minister Fahmi Fadzil said the gig worker bill, earlier slated for tabling this December, will likely be delayed to the next parliament sitting.